Trust me. Okay, let's get started on sales contract practices, which is chapter 10 in your textbook. A good amount of the things that we talk about in this chapter we've sort of already mentioned, and then we're going to get more specific about the standard offer to purchase and contract that's most commonly used here in North Carolina and what kind of questions you could see about that. But obviously, the sales contract is the basis for the transaction. This is the agreement between the buyer and the seller. I feel like it's always important to remind you that that word contract ultimately only matters in one place. And where is that one place? Court of law. Folks, generally speaking, we would love to think that everybody is going to honor everything that these contracts say. These are human beings. People don't do what they say they're going to do. So, realistically, many times it's not going to be about what the contract says in a real transaction as much as it is about what you can get people to agree to do on any given day. Very often people simply don't do what they've promised to do. If you are a perfectionist, you will have a hard time transacting business as a real estate broker. It ain't going to happen. People don't do what they say they're going to do, and you're going to have to triage it. You're going to have to find a way to work around it and find at least an acceptable solution, if not a happy one. But when we go through this chapter, we're focusing on what they're going to ask you on a test. And what they're going to ask you on a test is going to be much more straightforward of what does the contract say, what does the contract not say. So I don't want you to confuse that with the real world, okay? Reminder, don't draft contract language. That is the practice of law, and you guys don't want to be involved in it. If the contract doesn't say something that your clients want it to say, and you can't find what you're looking for in sort of a standard pre-printed form, what are you going to recommend they do? Talk to an attorney. Exactly. The contract that we're specifically going to teach you in this chapter is called the 2T. 2T is just the form number. It's not anything you have to remember. It's just the standard number that they've assigned it from the Association of Realtors. And if you want to look in your book, for example, I'll show you what I mean by that form number. On page 274, you have the standard offer to purchase and contract. Now look down at the bottom left of that form. What logo do you see there? The North Carolina Association of Realtors. Remember, you guys are not going to be realtors when you finish this class. That's a trade association. It's a union. You can choose to join it or not join it. Why are most of you going to be realtors, though? The MSLS, that thing, right. To have access to the MLS, exactly. That's why most of you are going to choose to be realtors. So the reason we teach you the realtor form is not because it's the only one that the Real Estate Commission says you can use. As a matter of fact, the Real Estate Commission doesn't make rules about what forms you can use. They just say you have to use one that's drafted by an attorney for use in North Carolina. We teach you the realtor version of the form because it's the most common. Because most likely if you do a residential transaction, you're going to use this form. That's just the reality. So that's why we choose to teach you this one. But it does come from the North Carolina Association of Realtors and not the Real Estate Commission. So I'm pointing that out. I'm hammering that home because you might see it on a test. And they won't slide it in there and ask you, does the Real Estate Commission approve forms? That's too easy. What they will do is make a statement that says the standard form approved by the North Carolina Real Estate Commission. Is that a true statement or a false statement? False statement, because the Real Estate Commission doesn't approve forms. That's not their job. That's not what they do. Okay? So we talked about the difference between realtors and non-realtors. Okay? We sometimes call it the offer to purchase and contract. And if you look on page 274, that's exactly how they refer to this thing. They call it the offer to purchase and contract. It's actually two different documents. It's first an offer to purchase. Once it's been accepted and that acceptance has been communicated, then it becomes a what? a contract. It's two different documents. It's an offer to purchase and it's a contract. As I said, the Real Estate Commission doesn't write the form. They simply say that the form has to have certain things on it. Just again, a reminder, we talked about that this morning. The contract cannot have any statements about commissions or liability disclaimers. I would say to star that in your notes. That's one of the big points from this chapter, that the contract can't have any statements about commissions and a statement could be anything. It cannot make any reference at all to commission or liability waiver. Those things just cannot be in there. Okay? Change this. This was a reference to the old book. On this slide it says Appendix D, page 664. It's actually within the chapter now on page 274. So just mark that out so when you're going through and studying, you don't go to the wrong page. Page 274 is the sales contract. Okay? This contract does conform with the statute of frauds. What is the statute of frauds? It says that certain things must be what? In writing to be enforceable in a court of law. And this particular contract obviously is in writing, so it meets the standard of frauds. We want to talk about some of the specifics of this contract, and then we'll get to broader topics about contracts. So I want you to turn to page 274, and I'm going to point out to you some of the more important things about this contract. I'm not going to go with you line by line through this contract. Here's the reason. It's going to be months before you're writing one of these out, making an offer for somebody. You will have forgotten everything I say when I go line by line through this thing. So with your permission, I'm going to focus down on the things that they're going to test you on about this particular contract. Is that fair enough for you guys? I will make you a deal. When it comes time for you to write one of these out in the real world, if your broker in charge is not sufficiently helping you, you call me and I will help you write it out. I will go line by line through it with you and make sure you understand every single line. But for right now, I want you to understand the things that they're going to ask you about with this contract. Okay? So this contract, this one that comes from the Association of Realtors, is the most common. Let's first talk about which transactions it should be used for and which should not. So somewhere you're going to need to make some notes about this contract. I don't care if you make them in the book, but these are going to be important things that you need to know about this contract that you could be tested on. Okay? Number one, residential resale properties. That's what this contract is made for. Residential properties that are resales. So what kinds of properties have I eliminated? New construction. Here's why. I'm going to show you the why of why you wouldn't want to use this as something in new construction. Let me find the paragraph here real quickly. Turn to page 277. All the way down toward the bottom of page 277, which is page 4 of the contract. It's under section 4, paragraph C, down at the very bottom. Does everybody see where I am? Buyer acknowledges and understands that unless the parties agree otherwise, the property is being sold in its current condition. So when people say to me, oh, this is an as-is sale, I want to look back and look at them and go, quite honestly, no crap. What does the contract say? The property is being sold what? As is. Think about new construction, folks. When you're writing a contract for new construction, do you generally want to buy it as is? No, because it's a piece of dirt, right? This contract does not work for new construction because of that language. Does that make sense for everybody? Why you wouldn't want to use it for new construction? You also don't want to use it in commercial transactions. Bluntly, in a commercial transaction, you're probably not going to have a fill-in-the-blank contract. You're probably going to need to get an attorney to draft a contract specially for any commercial transactions. There are some fill-in-the-blank ones for commercial transactions, but mostly those are pay an attorney to draft a contract form things. So we've got residential resales. The other thing we don't want to use this contract for is vacant land. And the reason for that is all these paragraphs that deal with fixtures and what's a fixture and what's not a fixture. Vacant land doesn't have any of that stuff. Okay, there's different issues with vacant land. So in your notes, residential resales, not commercial, not new construction, not vacant land. So the 2T, 2-T, and if you notice when I'm saying 2T, look to the bottom right on every page of the form. See where it says standard form 2-T? When I call it the 2T form, that's all I mean. That's just their numbering system for it. The Association of Realtors has a different number for every form. This is the 2T form. Okay? So what kinds of properties? Residential resales. Good. Good. Okay. So now, flip back over to page 274. Obviously, we want to list the parties to the contract, the buyer and the seller there at the top. Now down, and then we want to have a legal description of the property. And what's the most likely legal description we're going to use? What one do we mostly use as real estate brokers in this state? The plat map, the reference to a recorded plat map. Of course, we could put a meets and bounds description, but it would be very long and very cumbersome. So we usually use the lot and block system, the reference to a recorded plat map. And if you see, that's the one they kind of prefer in here because they have right there, legal description, plat reference. That's the first one they list for you. Okay? Get down to the money section. The first line in the money section is the purchase price. Well, that's fairly self-explanatory. How much is the buyer offering to pay for the property? Okay? Then this next line, highlight this line. You're going to be tested on this extensively. The due diligence fee. Well, let's first of all talk about that word fee. A fee, folks, is not a deposit. Notice the line below it, earnest money deposit. There's a reason they chose different words there. The big reason is this. A deposit is refundable under certain circumstances. What do you think about a fee? It is non-refundable. So if we say there is a due diligence fee made payable and delivered to who? To the seller by the effective date. And the effective date is just going to be the date that we go under contract. We are talking about a non-refundable amount of money paid by who? By the buyer to who? The seller. As soon as we do what? Go under contract. You just defined a due diligence fee. It's a non-refundable amount of money paid by the buyer to the seller as soon as we go under contract, just for the privilege of taking this house off the market. Yeah, Gray.
I got my due diligence money refunded. Did I just get lucky, or?
Unless there was some really weird circumstance, then the answer is yes.
So the seller was the one who backed out of the contract.
Why? The seller's not allowed to back out of the contract.
Well, there was a title issue that popped up.
Oh, so the seller breached the contract.
Yeah, exactly.
That's a different thing. The seller breached the contract. Then they are obligated to refund your due diligence fee. And if that's all they get, did you spend any other money?
Yeah, I did.
Did you pay for inspections, appraisals? They should have refunded all that too. So no, you didn't get lucky. You got screwed. There you go. Glad I could make you feel better about that today. Yeah. Because what this contract says is that if the seller breaches the contract, they not only owe you a refund of any money you've paid into the transaction, they also owe you any money you spent trying to buy the property.
Yeah, my realtor said I was probably going to have to get a court in order to get that.
Yeah, and your realtor is exactly right. You would have to go to court for all that, most likely. That's exactly right. That's exactly right. Well, at least they did refund a due diligence fee without you having to fight for it. So. But in general, outside of a breach, is this money refundable, this due diligence fee? No, it is not. This is paid directly by the buyer to the seller as soon as we go under contract, and it is gone, folks. I want you to put something in your notes beside this due diligence fee because I think it's going to help you later in the chapter. Option fee. This is another word, another description for an option fee. Here's what an option does. It gives the buyer all the power. It gives all of the power to the buyer. Because now whether we go forward becomes completely up to who? The buyer. The seller no longer has a choice. They don't. You've given all this power to the buyer. And that's the reason the buyer had to pay for it. Here's what the buyer's paying for with the due diligence fee. They're paying for power. They're paying for control. Because from a contractual standpoint, the buyer has all the control in this contract. And so I'm going to show you why I say that. Let me give you the correct page number here. Let's see here. Page 278, which is page 5 of the contract. It's the third paragraph down. Subparagraph F right there. Everybody see where I am? Buyer's right to terminate. Buyer shall have the right to terminate this contract for what reason? Any reason or no reason. By delivering the seller written notice of the termination during the due diligence period. I'm going to stop right there for a second. For what reason? Who has all the power here? The buyer does. Who has no power? The seller. And why does the buyer have all this power? They paid for it. They paid for it. That's why this money's non-refundable, because what they're paying for is power, and they already got the power. So they shouldn't get their money back because they got what they paid for. Does that make sense for everybody? They bought power. They bought control. The seller is along for the ride once they sign this contract, folks. Whether we go to closing or not is exclusively up to who? The buyer. That's the way this contract is structured. And what I want you to understand about it, that is the definition of an option. In an option, one party has paid for the right to have all the control. Normally, when we have a contract, we don't give a party a right to just change their mind. Doesn't that kind of defeat the purpose of a contract? A contract is a promise, right? Well, what promise has the buyer made here? What promise has the buyer made? Pay a due diligence fee. That's it. They haven't promised to buy this house. They've promised to pay a due diligence fee. And they've promised that they will terminate for any reason. But if they do, they have to do it by what date? What date does it say in that paragraph right there? By the end of the due diligence period. So what does it sound like they're paying for with this due diligence fee? A period of time that they can do what? That they can get out. That they can back out. Now let me ask you a question. Do they need, all right, so a contingency, let me define a contingency before I ask you about it. A contingency is the right to get out of a contract, right? You have a contingency when you're worried about something. You have a contingency for a loan, a finance contingency. What would a finance contingency say from the buyer's perspective? If I don't get what? The loan, then I don't have to do what? Buy the house. Do we need a finance contingency in this contract? What do you think? Why? Damn, I already told you got the right to get out for any. What if what? Mahogany asked a wonderful question. What if it's outside the due diligence period? Well, my gosh, then what should you do, Miss Buyer? Make sure you got financing before what? See, she already knows more about this contract than 90% of the licensed brokers in this state. It ain't the seller's problem that you didn't get your financing done. It's your problem because you didn't ask for what? Enough time. Because the due diligence period, look on page 275, down there at the bottom. It's a blank line. As the buyer, what should you ask for? Enough time to figure out, can you get your loan? Can you get the property inspected? Can you get the appraisal done? When I hear people say, well, I don't have enough time, well, whose fault is that? Yours. You didn't ask for enough. And folks, you better ask for enough, because guess what? That's all you paid for. Remember that due diligence fee? So now, having said all that, what do you think my response is when I'm the listing agent and the buyer's agent comes to me with their hat in their hand and says, you know, we really need more time on our due diligence period? What do you think I say to them? Either no or what? You used up the time you paid for. If you want some more, guess what? Pay for it. Because what they paid for was the time. Does that make sense for everybody? Are you following that? Because it's an important idea with this contract. The buyer's not bound to do anything here. They have all the power. They have it all. Because they have the right to terminate for any reason during that period of time. So they better make sure that period of time is long enough to cover anything you can think of that the buyer might need a contingency for. What are some things that the buyer might need to get out if it doesn't happen? Inspections. So should they make their due diligence period long enough to have their inspections and get quotes for any repairs that might need to be done? Yes. What else? We already talked about financing, right? How about if they got to sell another house? I've got to sell my house. People say, oh, I need to make this contingent. No, you don't. What do you need to do? You need to have a long enough due diligence period to allow you time to do what? Sell your house. Does that make sense for everybody? Here's what it accomplishes. It makes the contract clean. The contract is clean because we don't have to worry about piling all these contingencies into the contract. The contract we used to use, folks, had 47,000 contingencies in it. There was one paragraph in there, the property condition contingency. It is a condition of this contract. This is what it said. It's a condition of this contract. A condition is the same thing as a contingency, right? It is a condition of this contract that the following systems, if installed, will be performing the function for which intended. And it had a whole page of foundations, gutters, chimneys, walls, flooring systems, subsystems, sump pumps, garbage disposal systems, plumbing, electrical systems, ceiling fans, wiring. So if I said it's a condition of this contract that those systems will all be performing as intended, what did I just say that the seller has to now do? It is a condition of the contract that all those systems will be functioning. What is the seller agreeing to do? Fix them. Every single one of them. That's what the old contract said. It was a condition of the contract that all that shit was working. Every bit of it. Can you imagine what a nightmare that is? When you've got to go through one by one. And then it had this language. Performing the function for which intended. What is the function of a hot water heater? Go. Working. To do what?
Make sure it's hot.
Make sure it's hot. What, anybody else got a different definition? No? Well, if I'm the buyer, my definition is it better heat the water. It better not have any rust anywhere on it. It better be within the last 10 years. It better meet all code. See, the problem is I don't know what performing the intended function means. What's the function of a window? Go. She says open and close. That was her definition. So it's so fogged over I can't see out of it. But that's okay for her, right? Because her intended function was open and close. She said to keep the weather out. So she don't even care if it opens or closes. I don't need to see out it, and I don't need to open and close. Hers just said, so a piece of plywood works for her, right? That's the problem with that kind of language. So what we did is got rid of all of that. And we said, here, give the buyer whatever they want. But during what? A limited period of time. The longest due diligence period I've seen, 6 months. 6 months, because the buyer had to sell another house. They had to sell another house. Now, do you think that was a relatively expensive due diligence fee? Absolutely it was. If I was the seller, I wouldn't pull my house off the market for 6 months unless somebody was willing to pay me a heck of a lot of non-refundable money. And that buyer was. Yes, ma'am? Well, so Sarah brings me to my next point. Why bother to have both a due diligence fee and, if you look on the next line on page 274, the earnest money deposit? Insurance against what, though? It is insurance. You're right. Not for the due diligence money, but Sarah hinted on it though. She said, what if they go past the due diligence date and they still don't what? Close. That's the penalty. See, the due diligence money, you bought just that amount of time, right? But we come to this due diligence date, it's expected that the buyer's going to do what? Close, because they've gone past the time where they had the right to walk away. Now they have promised to buy the house. Does that make sense for everybody? So that's what the earnest money's for. The earnest money's for the time after the due diligence period. So what does that mean about if you terminate before the due diligence date? What do you think is going to happen to the earnest money? It's going to be refunded. Refunded. And that's what the thing says. What about if you terminate for any reason, I don't care what the reason is, after the due diligence date? What do you think is going to happen? The seller gets the earnest money. Simple as that. Cut, dry. Terminate before the due diligence date, what happens to the earnest money? Refunded to the buyer. Terminate after the due diligence date, what happens to the earnest money? Forfeited to the seller. As here's a phrase you've heard before, liquidated damages. What does that mean? What does liquidated damages mean? It means it was agreed to up front, and most importantly, what can't happen? You can't get more. So can the seller sue the buyer and say, you didn't buy my house, you owe me all this money? No. What do they get? The earnest money, and only the earnest money. Doesn't matter when the seller breaches. If the seller breaches any point in time at all, what the contract says is that the seller owes everything back to the buyer, plus any money that the buyer spent trying to purchase the property. So inspection fees, appraisal fees, any of that thing. The seller's not allowed any leeway in this thing. Remember, all power rests with the buyer in this contract. Does everybody understand? Yeah, go ahead, Mahogany. You're fine.
So if I'm the buyer and let's say I pay my due diligence fee and I'm supposed to have my inspections done before whatever time, and I still end up buying the house, but I didn't get one of my inspections done until after or whatever. When somebody does, when the buyer doesn't do what they're supposed to do, when does the seller get the due diligence fee? Do you pay it right there? Like if they still end up buying the house, do you get it at closing, or do you immediately get the seller?
Look. So her question is, when does the seller get the due diligence fee? I'm going to ignore all that other stuff, not because I'm ignoring it, because all that other stuff has nothing to do with your question, right? No. See, contracts are funny things like that. People love to talk about all these mitigating circumstances. Guess what? They don't matter. They don't matter. The whole point of a contract is to get past all that human nonsense that we put into everything, right? My mama died. Nobody cares. My dog got run over. Nobody cares. We don't. Contractually, as humans, of course we do. But contractually, see, all that extenuating, the buyer didn't get this done and they were supposed to. Nobody cares. When is the due diligence fee due? Look at that line right there. By the effective date. That's the date we go under contract, folks. So when is that money paid to the seller? Right then. We're under contract, you owe the seller that money. Whether you buy, don't think about buying, whether you do your inspections, don't do your inspections, whether you stay under contract for 4 days or 4 minutes, it doesn't matter. You owe them that money the instant we go under contract. So what about earnest money? Let's look at the contract, right? The contract on that next line says, initial earnest money deposit made payable and delivered to the escrow agent. And you're going to check how it's paid: cash, personal check, official bank check, wire transfer, electronic transfer. And then you have to check when it's due, either with this offer or within 5 days of the effective date of this contract. So, who is the earnest money deposit going to be made payable to? Not the seller. What does it say right there on the line? It says, to the escrow agent. So to a trust account somewhere, right? Escrow is the same word for trust. So the earnest money deposit is going to be made payable to a trust account somewhere. And you get to choose. It's either made with this offer or what? Within 5 days. It's your choice. Key here, though, Where did the due diligence fee go? To the seller. Where did the earnest money deposit go? Into the trust account. Because the due diligence fee belongs to the seller. As soon as we go under contract, does the earnest money deposit belong to the seller? No. Who does it belong to? Both. It belongs to both. Once we go under contract, it belongs to both the buyer and the seller. That's why you would need both of their permission. And so that's another important point. We've been talking about what happens to the earnest money deposit. We're talking about what the contract says happens to the earnest money deposit. What actually happens to the earnest money deposit? It stays in the trust account until both parties agree to do what? Whatever they agree to. Release it to one. So in the reality, even if the buyer terminates after the due diligence date, doesn't the buyer still have to release that earnest money to the seller? Say yes. Yes, they do. Because we don't ever release money from a trust account without what? Both parties permit. See, y'all got to remember, who is this contract language for? A court of law. It's not for us. So when you ask questions about what the contract says, that's one thing. But in the real world, you don't just release earnest money to the seller. You have to get the buyer's permission. And the buyer doesn't have to give their permission. Of course, if they don't, they run the risk of getting what? Sued. And they would lose because the contract says forfeited to the seller. And not only would they lose the earnest money, but they would also lose court fees and attorney's fees and all those kinds of things. So the reality is most of the time they are going to release it. But as a broker, we don't release it until we have both sets of permission. Everybody okay with that? So due diligence fee, when's it due? When's the due diligence fee due? Effective date. That's too fancy language. What does that mean? When we do what? Well, as soon as we go under contract, it's due. You owe it as soon as we go under contract. No, that's number one. Earnest money. Same day or within 5 days. And who's it payable to? Escrow account. Who's due diligence paid to? Directly to the seller. Due diligence fee refundable? No. Earnest money deposit refundable? Yes. When is the earnest money deposit refundable? Under what circumstances? If we terminate when? During the due diligence period. When is the earnest money non-refundable? For what reason after the due diligence? Any reason. Any reason. I don't care why you didn't close. Couldn't get a loan? Don't matter. Couldn't sell your house? Don't matter. Didn't get your inspections done? Don't matter. If you go past that due diligence date, that earnest money is forfeited to the seller. Is everybody all good on that? I mean, it's very cut and dry. Now, the good news is, as a buyer, if you notice, all these monies subtract and come up to a balance at the bottom. So what does that mean about your earnest money deposit and your due diligence fee? Are they part of the purchase price? They are. You don't lose any of this money unless you don't what? Unless you don't close. If you close, this is all just money you've paid toward the house. Is everybody good with that idea? Okay? That's the most important information from the whole contract. That discussion we just went through right there. You need to understand how the due diligence process works. Now, what things should you get done during due diligence if you're the buyer? Inspections, your loan, appraisal, title search, insurance. How about the best answer is anything it takes the buyer to be comfortable that they're ready to do what? Buy the house. So is it really just ultimately up to the buyer? I've heard people say, well, you have to get your inspections done during the due diligence period. No, that's not true. You don't have to do anything. What you have to get done during the due diligence period is whatever the buyer decides is important to them. Because if they don't get it done, what are they placing at risk? The due diligence is gone. What are they placing at risk? The earnest money. Once they're under contract, folks, the due diligence is gone. The only thing at risk from that point forward is the earnest money deposit. That's it. You got to understand the dynamics of that thing. And if you don't, I want you to be honest with me, because I promise I want you to get that, because that's super important for the test, and it's really important in the real world too. You're going to see this contract the rest of your career until we change it again. But it'll be around for a while. So you need to understand that relationship. Are you okay now? I told you that was the question we were going to be focused on.
Well, so we talked about it before a little bit, like, touching on the earnest money and like the trust accounts and stuff. I just didn't really understand what it was.
Okay, does everybody get it now? You know why there's a separate due diligence fee and an earnest money deposit when they are relatively refundable. So what change, if I just ask you the question in this way, what changes on the due diligence date? There's one thing that changes about the contract on the due diligence date. What is that one thing?
Where the earnest money goes?
So in other words, it changes from refundable to non-refundable. That's the switch that gets thrown on the due diligence date. That's the only thing that changes. The earnest money goes from refundable to non-refundable. It's like an arrow pointing from the buyer to the seller, right? Before the due diligence date, which way is the arrow pointing for the earnest money? To the buyer's side. Due diligence date swings over to seller's side. That's all. That's it. That is it. The whole thing. And at its essence, folks, that makes this an option. Because who has all the power during that period of time? The buyer does. Anytime the power is all on one side like that, it's really an option. Okay? Everybody good with that idea? Okay? Because it's the buyer's choice. Let's see. Other things we need to point out. On page 275, you have that line there for the escrow agent. That's just whoever the parties have agreed is going to hold the earnest money deposit. For your purposes on the test, you can fill in that line with listing firm. That's the most common place for the earnest money to be held, is with the listing firm. The due diligence period is obviously very important. You want to fill in the date of your due diligence period down here, whatever date you have agreed with, the buyer and the seller. And notice it says time being of the essence behind that due diligence date. What does that mean? No later than. It's drop dead, written in stone. And it actually says 5 p.m. on that date, time being of the essence. So it gives you a specific time. On page 276, which is page 3 of the contract, you have the settlement date. Notice what phrase is not behind the settlement date that was with the due diligence date. It doesn't say time is of the essence, does it? So what do you think that means about this settlement date? Very flexible. Super flexible, like yoga style flexible. You want to know just how flexible it is?
Please don't demonstrate.
No, I'm not going to demonstrate. That's a pretty good one, though. I give you credit. That was a good one. I give you credit. That was a good one. Over on page 282, just turn forward to page 282, paragraph 13. Show you how flexible that date is. Everybody see paragraph 13, delay in settlement / closing? Absent agreement to the contrary in this contract, if a party is unable to complete settlement or closing by the settlement date, but intends to complete this transaction and is acting in good faith and with reasonable diligence to proceed, and if the other party is ready, willing, and able, then the delaying party shall give as much notice as possible to the non-delaying party and shall be entitled to a... Does it say they have to ask for a delay, or does it say they're entitled to one? Entitled to a delay in settlement. If the parties fail to complete settlement and closing within 14 days, or to otherwise extend the settlement date by written agreement, then the delaying party shall be in breach. So when am I in breach of this contract for not closing? 14 days after the settlement date. So that's another way of saying, how long does either party have to delay this thing? How long? 14 days. Here's what you need to know about that. Don't make plans. If you're the seller, don't make firm plans until you actually know what your closing date's going to be, because They can delay up to 14 days. If you're the buyer, don't have all your mess loaded on a U-Haul truck until you know you're actually going to close, because they can delay up to 14 days. If you're the real estate broker, don't have plans for that commission because they can delay up to 14 days. Either party can delay up to 14 days. So how about if the seller is buying a new construction house and it's just not ready? Can they delay your closing while they wait for their house to be ready? They sure can. Doesn't say why they can delay. It just says they have a right to a delay. So be very aware of that. When you present this contract to your clients, make sure they understand that that date is not set in stone. Okay? Section 2 over on page 276, sections 2 and 3, and we'll kind of talk about them together. The fixtures and personal property section. Why would you, if you notice, each one has a line that you can write stuff in. You can write stuff in the fixtures section down there on a couple lines, and over on page 277 you can write some things in the personal property section. Why do you write things as a broker into the fixtures section? Are you trying to include those things in the transaction, or are you trying to exclude those things from the transaction? Exclude. Why would you write things into the personal property section on the next page? To include them in the transaction. Good. Good. Make sure you know that. We already talked about the fact that it's being sold as is. Remember, there are no contingencies in this particular contract. In other contracts that don't have this option or due diligence feature to them, you might have contingencies. So if you had something like a loan contingency, wouldn't it probably need to have the dates that you'd have to satisfy the contingency by? And satisfy the contingency being basically, if it was a finance contingency, to know you could get the loan. Don't you think it would have to like specify all the dates for all that sort of thing? Does that make sense? If you're writing a contract with somebody and the contract said, if I can't get a loan, I don't have to go through with it, wouldn't you probably say to them, well, when do you expect to know if you can get a loan? Right? So yes, if there were contingencies, you'd want to see all those dates, but we don't have contingencies. Look at the bottom of page 278. The Residential Property and Owners Association Disclosure Statement. Do you remember what we said about that disclosure statement? Who's required to fill it out? The seller is. The seller is required to fill that statement out. And provide it to who before they make an offer? The buyer. And we said if they don't provide it to the buyer by the time the buyer makes an offer, what does the buyer have? The right to do what? Terminate any contract for how many days? 3 days. Look at these options here that it gives you. It says, the first option, the buyer has received a signed copy of the North Carolina Owners Association Disclosure Statement, Residential Property and Owners Association Disclosure Statement. So you would check that box if the buyer had seen the thing. If they have not seen it, you would check the second box. Buyer has not received a copy. And then it goes on to explain that 3-day right to terminate if they've not received a copy. And the third option is that it's exempt from the Residential Property Disclosure Act. Okay, so you would check one of those boxes. On page 279, you would do the same thing for the Mineral Oil and Gas Rights Disclosure Statement. They either have seen a copy of it, or they have not seen a copy of it, or it's exempt. You would check the appropriate box. Does everybody understand that? Okay, good. Let's see, what else do we need to specifically talk about here? Over on page 281, it specifies the type of title, type of deed that the seller will convey. What kind of deed does it say the seller will execute? A general warranty deed, which means they will guarantee to the buyer that they have good title for what period of time? Forever. All the time. All the way back to the beginning of time and all the way forward into the future. So if your client, if your seller did not want to convey a general warranty deed, would they need to change that about this contract? Yes. And who would they need to have make that change for them? An attorney. Good.
They couldn't just cross it out and put.
Well, they could cross it out and put special warranty deed, but The other language in some ways refers specifically to a general warranty deed, so it's not just that language that would need to be changed. So the advice would be have an attorney make that change so that the other language that references, the things that happen in a general warranty deed would also be changed. Yeah, great.
If the contract's been modified, does it have to be made clear? Like, would they have to do away with like the standard form 2T or whatever?
No. So Dre's question is a good one. Do I have to make it clear that this is not the standard 2T? No, I don't. So for your purposes, you should always look down at the bottom. I always say you should read through the whole thing before you have your client sign it. But if nothing else, just look at the bottom and see if you see standard form 2T. Because if you see standard form 2T and you're familiar with that one, you know what your clients are signing. But if you look down there and you don't see the Realtors logo and you don't see that 2T, then you better be looking for the gotchas in here.
Right, but that's what I'm saying. If you have an attorney change one little paragraph, it can't say form 2T.
That is correct. So what the attorney would have to do is make an addendum to this contract that would specifically say, referring to this paragraph, seller's not going to convey a general warranty deed, they're going to convey it. So they wouldn't actually make the change on this page. What they would do is do an addendum that referenced back to it and said, this paragraph is no longer valid and here's the language that's going to go in its place. So it would be very clear that you were deviating from the standard contract. Okay? Gray's favorite paragraph is down here on page 281, the seller's failure to comply or breach, right there. And it talks about if the seller fails to comply or seller breaches this contract and buyer elects to terminate as a result of the failure, then the earnest money deposit and the due diligence fee shall be refunded to the buyer, and seller shall reimburse the buyer the reasonable cost in connection with buyer's due diligence. So basically, they owe you everything if the seller breaches. And if they had a title issue, that's a breach. Because clearly up at the top, they've agreed to convey good marketable title. So they've breached the contract if they can't do that. All right. Let's see. If you flip over to page 282, all the standard addenda are listed there. What does that word addendum mean? What are we doing to the contract? We are adding to the contract with an addendum. Whereas an amendment would be used to what? To change the contract. And that's it. I mean, those are the things you could potentially be tested on about that offer to purchase and contract. Okay? Obviously, the due diligence is the biggest part of it. Understanding the due diligence period, the process, the fee, when the earnest money is refundable, when it's not refundable. Knowing what kind of properties this contract should be used for and what kind of properties it should not be used for. If I ask you, does this contract have specific penalties for a breach for both parties, what would your answer be? It does. What's the penalty for the buyer breaching the contract? Don't say due diligence, because that's not a penalty. Due diligence is paid for time. What's the penalty for the buyer breaching? Earnest money. That's the penalty for the buyer for breaching, is the earnest money. Because it's not a breach unless the buyer terminates after the due diligence date, right? They have the right to terminate before the due diligence date. What's the penalty for the seller breaching? Refund everything plus pay the buyer back for anything they spent trying to buy the property. So does the contract have specific penalties for both parties? Yes, it does. Good. All right. That is it. We're not going to go through the vacant land version, but remember there is a vacant land version. All right. That means you can skip all the way ahead to page 312. And let's talk about offer and acceptance. We've talked about the terms offeror and offeree before. The offeror is the person doing what? Making the offer. The offeror is the person who's making the offer, and the offeree is the person who is receiving the offer. So in a traditional buyer-seller situation, who's the offeror, who's the offeree? offeror buyer, offeree is seller, right? What about a counteroffer? Do those roles flip? In a counteroffer, the roles flip. Good. So acceptance is the signature of the offeree. We still don't have a contract, though. When did we say we have a contract? Communication of that acceptance. That's exactly right. We don't have the contract until we communicate that acceptance. Any change whatsoever, it doesn't matter how small that change is considered a rejection. So anytime we make a rejection, that is a counteroffer. I mean, anytime we make a change, that is a counteroffer, which first and foremost is a rejection of the offer we just received. Even if it's something as small as the closing date or the due diligence date. If somebody counteroffers and comes back and says, you know, we're fine with everything, but we've changed the closing date to this, that is a counteroffer, folks, and that means you have killed the original offer. It doesn't matter what terms you change. You can't accept part of an offer. People say that all the time, but it doesn't work that way. Like, oh, well, my client accepts your offer, except they'd like to see the closing date be this. Well, then their client doesn't accept your offer. Does that make sense? Because you have to accept an offer as a whole thing. Any change is a counteroffer, and any counteroffer is a rejection. So, all offers should be definite. They should be in writing, and they should have any contingencies clearly spelled out if you're going to have any contingencies. Let's just talk real quickly about submitting offers to the seller, which is on page 312 in your book. The commission likes to test you on this, especially in this market where we have multiple offers all the time. If you have a multiple offer situation, as a broker, you submit all the offers at the same time. You don't submit them in the order they came in. You don't even say that to the seller. Why do you think they don't want us to say, like, oh, this is the first offer that came in, and then this one came in an hour later? Why would the real estate commission not want us to say that when we were presenting the offers to the seller? Bias. So what kind of bias could come from that? First come, first serve, right? People might have this innate sort of sense of, well, if they made the first offer, then let's take a look at that one first, type thing. Now, of course, they can do that. They can even tell you, I'd like to see the first one that came in. And if they did, that's exactly what you would do. That's fine for your client to do. What's not fine is for you to inject the bias into the situation. You shouldn't sit down and go, we have 4 offers and here's the first one that came in. What you should say is, we have 4 offers. Here they are. So on a test, how would you say you present multiple offers? All at the same time, or if there is an order to them, a random order. You know, just you don't put any sort of favoritism on the offers if you can help it. Okay, they like to ask you that question. So when we talk about acceptance and then communication of acceptance, acceptance is just the signing. When the offeree signs the contract, we have acceptance. Of course, if they don't sign it, if they make a change, then that becomes a counteroffer. And any counteroffer is, or any change is a counteroffer, and that switches the roles. Now they become the offeror, and the original person who made the offer becomes the offeree. That kills the original offer. Remember, when we talk about forming a contract, if you'll remember, I told you guys that one of the most reliable ways you could go about doing this is just to make a little chart with the buyer and the seller with a division between them. And to have communication of acceptance, we need to have lines going in both directions. We need offer and we need acceptance. Does that make sense for you guys? Because what's going to happen when you read these test questions, they're going to be very long and they're going to be very drawn out, and you're going to have to decide who's on what side of these transactions so that you know when we have communication of acceptance. You know, Tina's selling her home at 123 Main Street in Garner. She's represented by Micah of XYZ Real Estate. So I'm going to make sure and fill that out as I go, because I need to know whose team everybody's on. You following me so far? Brandy is the owner of the home at 123 Main Street. Or Brandy is making an offer on the home at 123 Main Street through her agent, Tasha. Is it with an O or an A? A. Thank you. Thought so. Her agent, Tasha of ABC Real Estate. So now, do I have them on the right teams? Yes. And I did that as I read through it, right? I just put everybody on the correct teams. And the reason I need to put everybody on the correct teams is because we're going to start bouncing arrows all over the place here. And we've got to be clear about when we're crossing that line between buyer and seller. So it'll say something like, Brandy completes the offer to purchase and sends it via email to Tasha. Tasha scans the offer and sends it over to Micah, who's the listing agent. Micah talks with Tina and presents the offer later that afternoon. Tina signs and accepts the offer with no changes being made and drops it back at the XYZ offices so that Micah can deal with it. At what point in time do we have a valid binding contract? And what is the answer to that? We don't. The answer is we don't. And it doesn't matter that it's been signed. Why don't we have a valid contract? We're missing an arrow, aren't we? We need something on this side going over here. And it doesn't matter from who on this side to who on this side. It can go from Tina to ABC, or Micah to Tasha, or Micah to Brandy, or XYZ to ABC. It doesn't matter which way, but we need another arrow coming back. And we don't have a contract until that happens, because that's what communication of acceptance means. Does everybody understand that? Are we good with that? Now, here's the interesting thing. What if I had said, so I said that Brandy submitted an offer to Tasha, and Tasha sent it to Micah, and Micah sent it to Tina, and I said Tina signed and accepted it. Well, let's change that. Tina made a change and then signed it and sent it back to XYZ. What did Tina's change do? It rejected the original offer, which erased that first line crossing the divide, right? That line no longer exists. So now, if XYZ sends it back to ABC, are we under contract? No, because now we're missing a line going the other way. You see how that works? And that's going to be what you need to sort through when you read these kinds of questions about communication of acceptance. So make sure you draw that divide clearly between the buyer and the seller so you know when we have communication of acceptance. So what ways can we communicate? Anyway, verbal, in person, email, text message, snail mail, smoke signals, telegraph. It doesn't matter. Anything works. You can communicate acceptance in any way. You don't have to actually see the signatures for it to be communication of acceptance. Can Sarah call me and say, my client has accepted your client's offer? Is that communication of acceptance? Yes. Absolutely. That works. There's no set rule about the way you have to communicate. However, if one party says communication may only be done via email, then that's what you have to use. But if they don't specify, then you can use any form of communication. Let's talk about the mailbox rule for a second. And when we talk about the mailbox rule, we're not only talking about this type of mailbox, we're talking about any type of mailbox, really. We think of the mailbox rule for this kind of mailbox because this is the kind of mailbox it was meant for originally. But it applies to any type. What other types of mail do we use? Email. The mailbox rule applies to email just as well as it does to anything else. So let's talk about the mailbox rule and what it is, and then let's talk about what it is not so that you don't make a mistake with it. The mailbox rule is a rule that says any acceptance, and remember an acceptance is a signature, right? So when we're talking about the mailbox rule, we're talking about a contract that's already got both sets of signatures on it. We're talking about communicating acceptance here. Any acceptance that's placed in the mail is communicated as soon as it's mailed, not when it's delivered. So, if Tina's selling her house to Jamie, Jamie makes the offer, sends it to Tina. Tina signs the offer, drops it in the mail back to Jamie. When did we go under contract? As soon as Tina did what? Dropped it in the mail. Did Jamie have to read the mail? No. Not required. It went under contract as soon as Tina dropped it in the mail. Can you apply that same rule to email? So it's communicated as soon as we do what? Hit send. Does it matter that the person on the other end has read the email or not? It does not. But now let's not confuse the mailbox rule. The mailbox rule only applies when we're crossing the divide between the buyer and the seller. They will try to trip you up on a test about that, because they'll say, Tina dropped the signed contract in the mail to Micah. At what point do we have a valid contract? Because they want you to say, oh, mailbox rule is as soon as she mailed it, right? But it's not, because who's she mailing it to? To Micah. And the thing about that is, Micah is Tina. Communication with the agent is the same as communication with the principal. Everybody on this side of the transaction is Tina. So if Tina's mailing it to Micah, guess who she's mailing it to? To herself. In the eyes of the law, she's mailing it to herself. So that's not going to be the mailbox rule. Does everybody follow that line of thinking? It's only the mailbox rule when it's crossing that boundary. All right, I'm going to skip some slides here because we already went through this. We did this in the contract itself. I don't like doing that, but we already did that. All right, we did that. We did that. Okay. In the old world, these are all the copies that we used to have. When I got into business, that's how old I am, I had to have 6 original signature copies of every contract. Buyer, seller, listing agent, selling agent. Who's the selling agent, by the way? The broker representing who? The buyer. Lender and attorney. 6 copies. Thank God we don't have to do that anymore. Now we have a law called the Electronic Transactions Act, which allows us to use scanned digital versions of signatures. It's a wonderful thing. So how many originals do I need to have now? What do you think? People say 1, but it's really not even 1, because if you think about it, I hardly ever have an original signature copy anymore. Because if I'm a listing agent and I'm presenting an offer, how did I likely get that offer? How did it get to me? Email. So it's already a scanned copy of a signature by the time I'm presenting it. And then my clients sign it. How many original signatures are on it? How many original signatures do I have on it when my clients sign it? Just 1, right? And then what am I going to do when I communicate it back? I'm going to scan it and send it back. So how many original signatures does that side have? None. Guess what? The law says that's fine. I love it. It's the most wonderful thing. And in reality, we don't even do that anymore. Now we send it out for digital signatures. Nobody even puts pen on paper. Just click in a box. Click, click, click. Signed. The law says that's okay. It's a wonderful time. How do we terminate offers? Well, the number one way an offer gets terminated is a counteroffer. A rejection, in which a counteroffer is a rejection. That's the number one most common way of terminating an offer. Expiration of the offer. Now, offers don't have a set expiration time. If you see that on the test, that is not the case. There is no set expiration time for an offer. However, could I set an expiration time if I'm the offeror? Could I say my offer is valid until Monday at 5 p.m.? Absolutely. Absolutely. And it would expire if I did that. They say within a reasonable time, but nobody has ever really told me what a reasonable time was. Or withdrawal. Can I withdraw an offer anytime prior to it being accepted? Absolutely. How about if I've said, this is another kind of thing they like to do on a test to you. Travis stated his offer would be valid until Monday at 5 p.m. On Monday at noon, he decided he wanted to rescind his offer. Is this allowable? Well, yes, of course. Just because I said it would be valid till Monday at 5, what that means is it would definitely expire Monday at 5. I can certainly still withdraw it anytime prior to that if I choose to. The only time I can't withdraw it is when it's been accepted. That's it. Death of either party would end or terminate any offer. Now, death of either party would not terminate a contract. That's a very different thing. An offer would not survive the death of the parties, but a contract would. You are still bound from the grave to act under that contract. Now, most of the time, from the buyer's perspective, that's not practical. I mean, it's very hard to force someone's estate to purchase the property, because the truth is most buyers are getting what to help them buy the property anyway? A loan. It's very hard to get a loan when you're dead. Very tough. Not seen it happen yet. But now, think about the seller's perspective. Can the seller's estate still sell you the property pretty easily? Yes. Yeah, and guess what? They have to. That thing is binding even after death. We actually just had a case not too many months ago down at the coast where that happened. There was a couple sisters who were sued for specific performance. Y'all remember we referenced that last week? We said specific performance was when the buyer was suing the seller to force them to do what? Sell the property. Well, they're not the ones who signed the contract. Their father did. He owned a beach house at Atlantic Beach. He put it on the market. They didn't want him to. It went under contract. He signed the contract, had a massive stroke, and died 2 days later. Well, the daughters didn't want him to sell it in the first place. So guess what they tried to do after he passed away? Terminate. Refuse to sell. Guess what? Buyer said, sued them for specific performance to force them to do what? Sell the property. And guess what the court of law did? Forced them to sell the property. So those contracts do survive death, but offers don't. Okay? Would have been the sellers, because they're the ones who are violating the terms of the contracts.
So any costs incurred by the buyer?
So, and actually, I think in that case, what the court did was actually reduce the sales price by the amount of the buyer's court fees. So all their attorney's fees, they had to catalog all their attorney's fees, and they actually reduced that from the sales price. So not only did they have to sell it, they had to sell it for less money to compensate the buyer for that cost. Okay, just some general notes here. Some of them we've already talked about. You don't need earnest money deposits for a legally binding contract. You don't need due diligence fees for a legally binding contract. Remember, we need consideration in a contract, but consideration is just the promise of the exchange of money. You guys remember that? When we talked about every contract has to have consideration. We don't need earnest money in the contract. We don't need due diligence fee. And even if the contract calls for a due diligence fee or an earnest money deposit, it doesn't mean that we're not under contract if it hasn't been paid. What do we call it when somebody doesn't do something they promised to do? It's a breach. A breach of what? Contract. So we're under contract. If they've promised to pay the due diligence fee but they haven't done it, the seller doesn't have the right to just stick that thing back on the market. It's still under contract. The seller has the right to proceed with any remedies under the contract, but not to just declare we're not under contract. They are indeed under contract. Okay? Closing date's not. Time is of the essence on the 2T contract. Of course, we can't talk about commissions. This one is a big one. Star this in your notes. A broker can never disclose the terms of one offer to another offeror. So what will we be talking about there? Think about the current marketplace. What could happen? We got a bidding war, another offer, and what do I do as the broker? I call one offeror and I say what to him? You got to do better. We've got an offer that's better than yours. We've got an offer that's this number. Do I have to even give the number, or giving them any indication of what the other offer is too much, right? I can't say we've got an offer that's better than yours. I can't give them any indication of what the other offers are at all. It's called shopping offers, and it's very much illegal in North Carolina.
Can you say we have other offers?
You can say we have other offers. You can certainly make that statement. But remember that as a broker, you don't really know what that means. If you're on the other side of the transaction and somebody says we have other offers, don't necessarily hear that as we have better offers. Because for all you know, the other offer could be $50,000 less than the one you've got on the table, right? All you know is they have other offers. So you really can't glean much from that. You know, you take it for what it's worth. And that's not a material fact, by the way. You're not obligated to disclose you have other offers. You can choose to, but you're not obligated to. And as we've said several times, any change represents a counteroffer. Notifying somebody who is the agent is the same as notifying the principal. Communication with the agent is the same as communicating with the principal. You don't need to communicate directly with the buyer or the seller. And as I mentioned before, just because money hasn't been delivered, it doesn't mean we're automatically not under contract. It just means somebody hasn't followed through with their promise, and then there are procedures for that. All right, turn in your book to page 316. Actually, 314. I'm sorry. Page is stuck together. I skipped a page. 314. Let's talk about the installment land contract. It's also known as a contract for deed. A contract for deed and an installment land contract mean the same thing. Here's what I call it: rent to own. So let me ask you this question. How many of you have ever heard of like a rent to own for like appliances or that kind of stuff, right? We've heard commercials for it. Am I making payments on it? Yes. Do I eventually hope to buy it from the person I'm making payments to? That's the goal, right? If I don't make all the payments, what does the person I'm buying it from do? What do they do with it? Take it back. Did I ever own it? No. I wouldn't own it until I had done what? Paid it off. That's an installment land contract. It's the same exact thing. I am making payments to a seller in the hope that one day I will own this thing, but that's not necessarily true, because when am I going to own it? Once I've completely paid it off. Let's focus on that for a second, though. That is dramatically and totally different than how we normally make payments on real estate. If I get a loan to purchase the property, who owns the property? No, the bank does not. If they owned it, they wouldn't have to go through a whole big rigmarole called foreclosure to take it from me if I don't pay. Who owns the property? The buyer, the borrower does. I have pledged it as collateral, but it's mine. And here's why that's important. If it's mine, can I decide when I get to sell it? Can I decide how much to sell it for? If I can't make the payments anymore, can I stick it on the market and sell it so that I don't get myself in a bad situation? Yeah. And if I've paid the balance down and I decide to sell it, who gets to keep the money that's left over after I pay the loan off? I do. Let's talk about an installment land contract. I get in trouble and I can't make the payment. Can I sell it? Can't sell what I don't own. I owed them 200 payments. I've made 199 of those. Can I sell it and keep all what I've paid in and just pay off that little tiny bit that I still owe to the seller? I can't sell what I don't own. So if I make 199 of those 200 payments and then I default on one, what can the seller do? Kick me out. And what do I get back of what I paid in? Nothing. Rent to own. That's exactly what it is. I'm making payments, but I'm not purchasing it until I have completely and totally paid it off. Who is holding title the entire time? The seller is. The seller is. When am I going to get the deed? When I've completely paid it off. That's why sometimes we call this a contract for deed. It's a promise for the deed, but the deed's going to come at a later time. Does that make sense for everybody? Now let me point out that this is very different than seller financing. In seller financing, I'm making payments to the seller, but who owns the property? The buyer does. In seller financing, title is being transferred to the buyer. I'm just borrowing money from the seller and then making payments back to them. Does that make sense for you guys? So, comparatively, which one is better for the buyer? Seller financing or the installment land contract? Seller financing, because if I own it, can I decide what to do with it, when to sell it, and how much to sell it for? Yes. And if I defaulted, what would the seller have to do to get the property back? Foreclose in seller financing. But in the installment land contract, do I get any of those benefits? No. So why on earth would a buyer agree to do this?
Better terms.
Not going to be better terms. Can't what? Can't buy it any other way. Can't get a loan. My credit sucks. I don't have any credit. Whatever. The reasons are, this is last chance saloon, folks. You're doing this because the only other option to doing this is being just a renter. Rent to own is one step better than what? Than rent. That's a really good question. Mahogany's question is this only land? The answer to that is no. This can be any real estate. So can you buy a house this way? Sure. Sure you can. Who does this benefit more, the buyer or the seller? Seller. Hugely advantageous to the seller. Now, of course, for a buyer who doesn't have any other option, it's better than no option at all. But it's pretty tough. You get to this point as a buyer, you are definitely at the bottom of the barrel as far as your options go. Does that make sense for everybody? Why you would do it, what the motivations are? From the seller's perspective, this is a pretty good deal. What's the only downside from the seller's perspective here? There's only one.
If the price goes up, you're locked in.
I'm sorry, what?
If the value of the property goes up, you're locked into the agreement.
Right, if the value of the property goes up, I'm locked into this price, which is just a follow-up on I'm not getting my money right now, right? That's the big disadvantage to the seller, is I'm not getting my money right now. So, just like the buyer would probably not do this unless they couldn't get a loan, why would a seller agree to this? They can't sell it. They can't find another buyer. Generally speaking, this is the match made in hell right here. This is the buyer who can't buy anything else buying from a seller who can't find anybody else to buy. And they have ended up here together, tied up in this deal.
So how does that make it the better for the seller? Like if I was a buyer and I couldn't get a loan because my credit stuff, whatever, but I really wanted to own my own home, wouldn't it be advantageous for me to find something where I was renting it, but I would eventually own it?
Sure, but I mean relative between the buyer and the seller. Who has the power is what I mean.
Okay.
I mean, who is in the more advantageous position here? And
That sounds like it sucks for the seller because no one wants to buy their house, so eventually they're just going to take like rent payments
Right.
from someone until.
right. And so the reason they both are doing it is because it's better than the next outcome. But I guess I should have stated it better. The relative to each other, who has the power, and that's going to be the seller. that's going to be the seller. Whereas in the seller finance deal, relative to each other, the buyer's probably in a better position in a seller finance deal. Does that make sense for everybody? Because title's been transferred to the buyer in seller financing, whereas in an installment land contract, it has not. Is everybody good on these? Here's what you need to know as a real estate broker. You can't do this. This has to be an attorney. As a matter of fact, it probably needs to be two attorneys. The buyer needs to have an attorney. The seller needs to have a separate attorney. You might get paid a commission, and that's fine. But as far as actually executing this deal and dealing with it, send them to an attorney, because there's going to be so much involved with one of these that you don't want that liability. Okay? The buyer would usually be responsible for property taxes, assessments, homeowners' dues, and all those kinds of things, which makes it even worse. They don't own it, and they're paying all these expenses as well. All right, and we talked about the advantages and disadvantages. Obviously, from the buyer's perspective, poor credit, but disadvantage would be the default penalty is very harsh, and they cannot use the property as collateral. Okay? We talked about that. Okay, so options to purchase. Now, page 316. In the option to purchase, which hopefully is a little bit easier to understand now that we've gone through the due diligence contract. In the option to purchase, the optionor is giving the optionee the right to buy the property at a fixed price during a stated period of time. It's the option E that has all the control. Doesn't that sound a lot like that due diligence contract that we already talked about? It's exactly what it is. So you think there's going to be an option fee associated with this thing? Absolutely. And it's going to be paid by who? The optionee, which in this case is usually the buyer or seller. Which one's going to be the optionee? The buyer. The buyer's going to be buying an option, and they're going to be paying an option fee to the seller, which basically locks the property down for a certain period of time and at a certain price. Does the option holder or optionee have any other rights in the property during that time period? Like, can they use the property for anything, or they just basically have the right to buy it? Just the right to buy it. What right does the seller have during that period of time? To use it, pay taxes. Do they have the right to back out of this contract? No. The seller is completely locked in. The buyer is not. This is done in commercial real estate a lot. Quite often in commercial real estate. Let me give you an example of why. So, let's say Walmart is interested in moving to some town somewhere. I'll use my hometown, Tarboro. There is one there now. I can't believe it. There was nothing there when I lived in Tarboro. Not that Walmart's a big destination, but when I say nothing, there was nothing there when I grew up. But there's a Walmart there now. When Walmart comes to a town like that, they have to decide where they're going to locate. Is that going to be big news locally in a small town? Especially if you own property that they're considering purchasing, right? If you find out that your buyer is Walmart, what's going to happen to your sales price for that property? It's going to go up substantially. So Walmart is not going to come in and buy or offer to buy this property. They're going to have some subsidiary you've never heard of come in, and rather than focus on one property, they're going to say, okay, here are 4 potential locations. Let's buy options on all 4 of them. And so they're going to lock down pricing on all 4 of these. They're going to pay 4 option fees, knowing that they only intend to purchase how many of the properties? 1. So they're going to lose 3 option fees, but that's probably a lot less money than if they just announce, hey, we're Walmart, we're here in town, and we want to buy this one property. Does that make sense for everybody? So they're going to pay 4 option fees. Now, once they've got those options locked down, guess what? They're going to have a press conference. Now they don't care. We want the whole world to know who they are. Because now they've got to work through the approval process with the town of having stoplights put in. And they're going to do their research on all 4 pieces of property. And now they get to decide completely which one they want to use. And can the sellers do anything about it? Nothing. So you just found out that you're selling your 10 acres to Walmart for $25,000. Ugh. and you don't have a choice. That's a use of an option. It puts all the power in one party. Does that make sense for you guys? Okay, good. And the option fee can be credited to the purchase price. It doesn't have to be. In the case of the due diligence contract, it is credited. You know, the due diligence fee is part of the purchase price. All right. Obviously, options should be in writing. The statute of fraud, they're covered under the statute of fraud, so they are required to be in writing, and they have to be recorded. Because they impact title to the property, they have to be recorded. My tests? Thank you. No, we don't eat lunch around here. We're finishing up right now. Okay? And obviously the option should say what the option is. What does it mean to exercise the option? How long is it good for? All the different terms that go along with that. Okay? And the last thing I want to touch on is a preemptive right on page 317. Preemptive just means ahead of time. A right of first refusal. A right of first refusal is not nearly as strong as an option. In an option, the buyer is paying the seller, and the buyer now has the power to force the seller to move forward. Does that make sense? The seller has no decision-making power whatsoever in an option. In a right of first refusal, Tina's got a piece of property that I might like to have. I don't even know if I really want it, but I might like to have it. Here's what I know, though. I know she might sell it to Emily, and I definitely don't want Emily to have it. So, I pay Tina some money, and she agrees that if she decides she ever wants to sell her property, she'll give who the first chance at it? Me. Can I force her to sell it? No. You see why it's not an option. Does that make sense? It's not an option because I can't force her to sell. She hasn't agreed she'll sell it to me. She hasn't agreed the price she'll sell it to me for. She hasn't even agreed she'll sell it at all. She's just agreed that if she does decide to sell it, who will get the first chance? Me. So it's not nearly as strong as an option. So generally speaking, how would you compare the money paid for this versus an option fee? You think it's going to be more or less than an option fee? Significantly less, because it's less power. It's just less power. Right of first refusal. You do this a lot of times with property that neighbors your own. You know, like if you have some, I've seen people that maybe their home backs up to farmland. And they're tickled to death that it's farmland. They don't really want to own that land, but they like it as farmland because it's peaceful and it's serene. But what do they not want back there? Housing development, trailer park, Walmart, what, you know. So they might approach the farmer who owns that land and say, you know, Mr. Smith, I don't really want to purchase your land, but I would really love to have the first chance at it if you decide you want to sell it. That would be a good use of a right of first refusal. Make sense?
Is there any reason why you would want to pay money for that? I mean, it seems like it would be one of those things if you have a relationship with them, you could say, hey,
the reason you're paying money for it is it gives you the legal right to match anybody else's offer. So not only do they have to give you the first chance at it, but they have to tell you, okay, you know, here's the offer I already have. Do you want to match that offer? And if you're willing to match that offer, then they have to sell to you. So that's why you'd be willing to actually pay something for it. So, because it basically guarantees that you can buy it for the same price that anybody else can. You don't have to beat that offer, but you have to match it. So, you know, if Mr. Smith comes to you and says, well, you know, I got a buyer, it's Walmart, and they're willing to pay me, you know, $50,000 for the lot, as long as you're also willing to pay them $50,000, then you'd have the opportunity to buy it. Make sense? That's it for the contracts chapter. How y'all feel about that? Pretty good? It's a lot of material. Well, here's a question for you.